Welcome to Studio CF, the video law blog by the Carlton Fields Law Firm. My name is Joanna Garcia, and I'm a shareholder and business litigator at the firm. Joining me is Fentress Driscoll, who is also a business litigator at the firm. And the topic for this episode of Studio CF is personal electronic devices and social media in the workplace. Fentress, I think everyone is familiar with websites like MySpace and Facebook, but to start with, what is social media?
Certainly MySpace and Facebook are two very popular examples, but social media can also include sites like YouTube, blogs, both personal and employer-sponsored, Twitter, and professional networking sites like LinkedIn. So social media doesn't necessarily occur just in a social context. It has the capacity to impact our professional lives as well.
In what ways has social media impacted the modern workplace?
For starters, we now live in an age where social media is ubiquitous. I mean, it is everywhere. Twitter alone reports that it has over 100 million users. LinkedIn has more than 120 million users. Facebook reports that it currently has 750 million active users, this up 250 million from 2010. Facebook also reports that among its users, 250 million of them access social media using personal electronic devices, including cell phones, iPhones, and the like, which means that the ability to participate in social media can be taken with you. It also means that employees can now participate in social media while they're at work if they have their personal electronic devices. There was a study done by the Nucleus Research Group out of Boston in 2009 that concluded that 77% of workers had Facebook pages. Of those workers, 2/3 of them accessed their Facebook pages during work hours. Of those workers, 87% of them could identify no clear legitimate business reason for why they had accessed their Facebook page during work hours. So the study ultimately estimated that the employer lost around 1.5% in productivity for allowing employees to participate in Facebook. Another way that social media has impacted the workplace is that employers need to be on guard about potential risks to the company, including possible disclosure of confidential or proprietary information on social media sites.
Should employers regulate their employees' use of social media in the workplace?
Yes. The first step is to identify potential risks to the company that social media may impose. If the company does not already have a social media policy, they should develop one. Some areas to regulate would include rules against discriminatory statements, rules against the disclosure of confidential or proprietary business information, rules prohibiting any sort of communications that contain sexual content or innuendo, making very clear to the employees that that sort of behavior will not be tolerated. This also means that the company needs to take steps to educate their employees with training, regular ongoing training. Also, the employer wants to be careful to set up standards in terms of consequences for violating the rules. And the company also needs to make sure that they regularly update their rules and their standards, because this is a dynamic area of the law. It's constantly changing, and sometimes the law doesn't quite keep up with the technology.
Is there anything else employers should be aware of?
Yes, employers should be aware that employees' misuse of social media could lead to litigation. For example, hostile work environment claims or discrimination claims. Social media outlets such as websites and blogs provide another opportunity for employees to engage in misconduct, including posting negative comments about the company or about other coworkers. At least one court has held an employer liable where it didn't take steps to intervene and stop some of its employees who were posting negative comments about a coworker on the company website, because the company's website was viewed as an extension of the workplace. Additionally, employers should be aware that they can face negligence liability if they breach their duty of care from preventing employees from engaging in illegal activity. For example, using a workplace computer to view child pornography. Also, potential areas for liability include astroturfing, where employees may post fake positive comments about the company's services or products that can run afoul of Federal Trade Commission guidelines.
What are some issues that arise when social media is involved in discovery?
The biggest hurdle is the ability to gain access to the information that you seek. The Federal Stored Communications Act prevents electronic communication providers from disclosing the content of stored electronic communications as well as the name of the subscriber without either having consent, meaning that you actually get some sort of a written consent from the subscriber to release the information, or you get authorization, which would mean something like a court order directing the subscriber to give you consent to then take to the communications provider to get the information that you're seeking. Also, Rule 45 subpoenas have generally been held to not be an exception to the Stored Communications Act.
And what are some issues that arise when personal electronic device information is involved in discovery?
That's a great question. As we discussed earlier, many people are now participating in social media using their personal electronic devices. And the issue with data stored on such devices is that it's extremely vulnerable and volatile, and it can be easily erased. So spoliation can be a big issue here, particularly if the parties can prove some sort of intentional spoliation. The consequences can be quite severe. We're starting to see federal district court grant adverse inferences in such situations, and also sanctions if the parties can prove that emails or electronic images and the like that were stored on a cell phone or some other sort of similar device were intentionally destroyed.
Finally, Fentress, what are some steps that litigants can take to preserve information on personal electronic devices?
Some steps might include freezing the device to preserve the information in whatever state that it's in. You might also clone the device to create a copy of the data that's stored there. Another possibility is to hire a forensics professional to take very professional steps to preserve the device. But truly, this is an evolving area of the law. It'll be interesting to see what other sorts of methods develop as the law develops in this area as well.
That brings us to the end of this episode of Studio CF. We hope you found the discussion informative. Please take a moment to browse our other legal topics and be sure to check back with us each month for new episodes. Thank you for watching.